In today's session, the committee will engage on the topic of credit services review. On behalf of the committee, I want to welcome Master of the High Court, Edmond Honohan. You're very welcome. Honoured to have you here, and we're looking forward to your contribution. In terms of privilege, I would ask members and witnesses to note that you are, when you're here on campus, you have full privilege, but should you be off campus joining us, you only have partial privilege. And you're all reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise or make charges against a person outside the Houses or an official either by name or in such a way as to make him or it identifiable. We'll commence our meeting with an opening statement from the Master at Honohan.
Thank you, Caoimhín. Apparently the Minister has decided not to incorporate any of the optional measures in ease of distressed borrowers which were suggested by the EU, but this decision is not his to make. It is legislative in nature, and Article 15.2 of the Constitution is engaged. In short, it is a matter for the Oireachtas and primary legislation. Further, the Minister's decision was made not by himself but by his officials, acting in line with the presupposed authority which relies for legality not on formal delegation but on the Carltona principle. As a member state of the EU, Ireland's measures to implement a directive cannot be validly effected by a public servant, however senior. Carltona does not stretch that far. The committee should know that the general view is that officials in finance are locked in the mindset of moral hazard. This is illustrated yet again by A, the 2-year delay in actioning the 2021 directive. That's the one we're concerned with today. The amendment to the 2014 directive by Article 28 could even have been fast-tracked as a one-liner if anyone cared enough. And B, by the general tone of the questions raised in the public consultation regarding the options, it is there presupposed, but on what authority, that Ireland will not respond positively to the suggestions. Lobby groups' fingerprints are plain for all to see. Hard law not transposed. Of even greater concern is the proposal to treat the hard law directive as transposed fully by creating new soft law guidelines coupled with central bank monitoring of the explain or comply variety. The directive requires Ireland to oblige credit purchasers to start offering forbearance. If it's to be a legal obligation, failure to comply must end with a penal sanction. It is to be noted also that where the central bank is the agency charged with the implementation of the directive, which will be directly effective come the end of this coming December, failure by the bank to enforce the obligation aforesaid will not be shielded from suit or liability. The provisions of the Central Bank Acts notwithstanding. Some questions about, title to collateral. Committee members will have noted the Central Bank's statement in a letter to me dated the 9th of June 22 that, quote, questions of title by reference to land registration laws fall outside the competence of the Central Bank, end of quote. Is this a skill set problem or what? Surely the prudential remit of the bank requires detailed overview of balance sheets, of risk management, of capital adequacy, especially for our proprietary trading desks. The bottom line for a bank's loan portfolio shouldn't be audited on the strength of a bank's stated valuation without checking legal title. How else do you weigh the risk of contagion? Equally concerning for me is the fact that, my correspondence notwithstanding, the Central Bank appears to be uninterested in the topic and unlikely, apparently, to undertake any investigation. The regulator is taking the regulatee at its word, and such naive, light-touch supervision is now apparently also proposed in respect of credit purchasers and servicers. This no questions asked attitude is shared with the CRO, the Companies Registration Office, the Land Registry and the Charities Regulator, which rubber stamp the activities of the charities, which are the shareholders in orphaned private capital intermediaries. These agencies all got the memo. Revenue is an honourable exception. Unfair terms in consumer contracts. Statutory Instrument 14 of 2020 designates the Central Bank as a competent authority for the enforcement of the EU's 1993 Unfair Consumer Contract Terms Directive in order to ensure compliance with, quote, laws enhancing the protection of consumers' economic interests, end of quote. Who knew? Does the central bank know? Or is it a rhino, a regulator in name only? Here's a question you should put to them. What reason do they consider valid for the purposes of subparagraph J of paragraph 1 of the annex of terms referred to in Article 3.3 of the 1993 Directive as scoped at subparagraph 2b of the same annex? Or perhaps you could put it more succinctly thus. Is there ever a valid reason for supernormal profits? Here's another one for you. Is it in good faith for a loan originator to use the assignment option to sell in market covert, that's not overt, covert, to a connected but unregulated purchaser? How can a borrower's consent be considered as fully informed? Shouldn't the borrower at least have an implied call option at the same discounted price? Or would that be too administratively difficult, as we are informed when the portfolio sales were commenced around 2012? Perhaps the borrower's blind consent to assignment is covered by subparagraph 1p of the annex above referred to, and therefore unfair as defined. Some questions about forbearance and proportionality. Compliance with the new directive will be assessed by reviewing outcomes case by case. 1. Will the servicer and the purchaser and the originator all be obliged to complete SFS-style recitals of loan history, including pre-assignment facts as recorded on their files? 2. Will the financial profile of the credit purchaser be interrogated? See, Rehayes, a debtor, 2017, it's a High Court judgment. A credit purchaser, quote, is not a lender, and accordingly the test of unfair prejudice regarding its interest must be seen in the light of investment returns and not the cost of the capital needs of the creditor in the future. That's Judge Baker. 3. Will the proportionality be assessed by reference to the face value of the debt or the book value? 4. Will the servicer have to fully account for any alleged, that should be GRG-style, engineering of default? That's the RBS scandal. 5. For the assessment of proportionality, will the purchaser's cost of funds be adjusted for tax avoidance interest limitation rules? 6. Should the charitable status of the ownership vehicle of the credit purchaser be subject to revocation if a credit servicer acts without regard to a borrower's right to fair treatment and proportionate forbearance? Is the central bank competent to override the charities regulator on this point and or to determine the liabilities of the shadow SPV directors? The new moratorium, when I wrote to Oireachtas members last month, I described the legal changes as a, quote, new moratorium. And perhaps I should explain. The directive obliges Ireland to require credit purchasers to forbear. It is only when bona fide efforts to resolve matters have failed that proceedings to obtain recovery of collateral can commence. Judges need to be told this. It is EU law, but they still need to be told. Will the Oireachtas tell them? Thank you, Chairman.
Thank you very much.